Right, let's get back on the record, and we are. So I reviewed the portions of the hearing, but luckily also Judge Gannett gave specific findings and conclusions at the end of the hearing, which I listened to 3 times just to make sure, because his voice is a little bit.
Your Honor, I'm not sure that my
It's not recording.
Is recording.
How do we make sure of that?
The clock is on.
Yes.
Testing. 1, 2, 3, testing. Back on the record.
Okay. Unfortunately, the clock running isn't always an assurance. But, so I will repeat then that I listened to portions of the record of the prior hearing, and most especially I listened 3 times to the judge's findings and conclusions, which came at 10:58, and then to the dismissal, and then to the conversation with Ms. Crow after the dismissal. So I compared the petition in that case to the petition in this case. 2 out of 3 of the allegations are precisely the same that were previously dismissed. So those 2 are not, can't be relitigated. So you can't come back and bring the same allegations from the same dates over after a judge has already made a conclusion on those. There's only 1 allegation that is not the same. I am willing to hear some evidence on that allegation today. So I am going to deny the request to continue because we've limited it down to 1 allegation. And even based on that 1 allegation, I have some concerns that Judge Scott, I have concerns that you may not have told Judge Scott that you were bringing 2 of the exact same allegations that had already been dismissed by a prior judge when you got her to give you this newer order. I haven't listened to that FTR to see what you told her that day, but did you tell her that 2 of the 3 allegations had already been litigated and dismissed?
I'm not sure. Every time I've gotten a restraining order against Mr. Fisher, the first one, he blocked me into my driveway for 3 hours.
Yeah, my question is about your conversation with the judge. When you came at ex parte to get your temporary order, did you tell her that 2 of the 3 things you wrote into your petition were things that had already been dismissed by a prior judge?
I don't believe so, but I was trying to protect my car, and then he towed my car every time I've been trying to protect myself. He wants me out of there. I can't do that.
That's a third concern, actually, because restraining orders are to protect your physical safety,
yeah,
not
and I
your
don't
property.
feel safe with him being able to tow my car and leave me stranded there.
Okay, let me swear you in. Why don't you stand up and raise your right hand to be sworn? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you may be seated. So tell me why his...
Your Honor, may I? Sorry.
Yes.
Move to exclude witnesses if Mr. Archer intends on testifying today.
Sure. So, Mr. Archer, if there's a chance that you will want to testify under oath today, you will need to wait in the hall from this point forward. If you will not be testifying today, you wouldn't be allowed to testify if you remain in the room any further. So will you be waiting in the hall or will you be staying here?
Yeah.
I couldn't hear him.
No, I wasn't calling him as a witness or anything.
Okay. So
Sorry, Your Honor. I wanted to clarify which of the incidents are...
It's the last one.
One?
The last one is the new one. So the 2 that happened on
November 8th.
I thought you had told me that. I thought
well, Your Honor, there's a November 12th. The petitioner dated them November 8th, November 9th.
Hang on.
November 12th.
Hang on. I'm trying to get back to answer your question so that I can proceed with my questions. So the hearing was on September 25th. Everything that occurred prior to September 25th was litigated at that hearing. The only item in the petition for this hearing, today's hearing, that occurred after September 25th is alleged to have occurred on November 2nd. That is the, quote, false police report claiming the dwelling was a business and claiming her spouse had attacked his business, etc.
Your Honor, I certainly don't want to make this more confusing or burdensome for the court, but that doesn't comport with respondent's understanding of the petition. I'm looking at allegations on the last page. There was a supplemental page added to the petition, Your Honor. It has dates of 11/8, 11/9, 11/12, and then 10/1 as well, which is kind of just a general. All of them seem to relate to the dispossession of a vehicle and the sort of fallout. I can approach, Your Honor. I have a.
No, I'm looking at it. Okay. It's in the file. There's 4. You said 10. I mean, there are 4 on that supplemental page.
Yes, I think there's a total of 8 or 9. On the last page, though, there's 4.
Well, as I said a moment ago, the ones that happened before the prior hearing, which was held on September 25th.
Right, Judge. All 4 occurred after September 25th on the supplemental page.
Yes, but you said 10.
I said 10 what?
I don't know. You're hard to follow. But I was trying to identify the portions of this that are still potentially at issue. Okay. And I was trying to ask her questions to further identify whether they're at issue. When you said, no, there are 10, and you wanted to know which ones of them.
I might have misspoke, Your Honor. What I meant to say was that Your Honor had said that the 11/2 was the only incident that occurred after 9/25. The petition has a supplemental page which has 4 additional incidents that occur after 9/25, none of which are 11/2. So I'm just simply trying to get an understanding of what
11/2 is at the bottom of page 3 of 5, right before the checkbox for additional page attached labeled instance of abuse 180 days.
Correct, Your Honor.
So that's where the 11/2 one is. Are you with me there?
Yes, Your Honor.
Okay. And then the subsequent page that you have located adds 4 for a total of 5, with dates ranging from October 1st through November 12th, but not in chronological order.
That's correct, Your Honor. I apologize if I errantly said 10.
Okay. So is there anything else we need to clarify before I can speak further with Ms. Crow?
I just wanted to make sure that all 4 of those incidents are the ones that 5 of those incidents are the ones that are at issue today.
So this hearing is atypical. We haven't even really, I'm considering everything that's happened up till now as a form of opening statement for each of you.
Thank you, Judge.
And I'm considering the information that I gathered from the findings and conclusions of Judge Gannett to inform what the context was going into these subsequent events. And I am trying to identify whether, if Judge Scott had known what the conclusions were on the prior events, whether these subsequent events could have in and of themselves given rise to this order. Because it appears to me that Judge Scott did not know what the context was when she entered into
I agree, Your Honor.
her review. Okay.
I think as long as we're just proceeding under the notion that everything that happened after 9/25 as alleged in the petition is relevant, that satisfies my concerns. I just wanted to make sure that I knew when to object if we were outside the scope and when to stay silent.
Okay. And I do wish you good luck with that because the scope is a moving target. But yes, my position is that Judge Gannett made a ruling that is fixed and unchangeable about events that happened up to his ruling on September 25th.
I agree, Your Honor. Thank you.
Okay, Ms. Crow? You can sit down if you like.
When I got that order granted, I just remembered the judge, she was a female, and she said, when she granted the order, she said, I have seen you have multiple orders against this person before, and I remember her acknowledging that, and she granted it anyway. To get my car back.
That doesn't change the fact that the decision that was made by a judge after hearing evidence from both sides on September 25th was a full and final decision on everything that happened up to September 25th.
Okay.
So putting those back in doesn't renew them or revive them in any way. Got that?
Yeah.
Okay. So let's start with you telling me about October 1st.
I don't.
Well, and frankly, what you said is that throughout the 5 months I have lived there, which actually, I suppose that the 6 days between September 25th and October 1st are part of that 5 months, but I don't want to hear about the full 5 months because 4 3/4 of those 5 months were happening prior to September 25th.
We would move to strike that, Your Honor, as vague and in the context of a restraining order unconstitutionally and permissibly vague. So we'd move to strike all allegations related to October 1st.
I think that makes some sense because the October 1st allegation tries to bring back in all of the stuff before September 25th. So let's go to the supplemental page.
I don't know what's going on. I have no idea what's happening.
What's happening is that you have tried to make a casserole with food that's already been eaten and digested and rolled upon,
Right.
plus food that was prepared subsequently.
Right.
I'm trying to separate the ingredients of your casserole so that I can look at the ones that weren't already digested and weren't already completed, gone through someone's system, decided, and over. So it's difficult to do because the dates that you put in your petition for this case are jumbled. They're not in sequential order, but we have to unjumble them. So I was trying to go in chronological order, which took us to the last allegation on the last page, which was October 1st, because that would have been the very next date after September 25th.
I don't have
You
that.
can't tell. Oh. Can you print her out a copy of her petition? Thank you. And while she's bringing that to you, I will also just say for the record, because I don't think I repeated it, that what Judge Gannett said, among many other things, is that he had absolutely no concerns about you being at risk of physical harm, that this was a landlord-tenant matter, that you and your partner had been violating the terms of the tenancy agreement, that you needed to comply with it and comply with it ASAP, were his words, to get your property off, and that would resolve the other issues that were causing conflict between you. So that was essentially his findings and conclusion at the end of the last hearing.
On December 10th?
September 25th. September 25th was your last hearing. So if you look at the last page of that petition, which says at the top, incidents of abuse -180 days continued. Do you see that?
No.
Can you go help her?
Oh, yes.
Oh, okay, never mind.
Sorry.
So at the bottom of that page, it says date October 1st, 2025. Do you see that?
Yes.
That was what I was just talking about, where the first phrase says, throughout the 5 months I have lived there. Do you see that?
Yes.
So I'm excluding that one because October 1st was only 6 days after September 25th. And so by talking about the entire 5 months, you're taking it back into that digested portion of the casserole. So the next date that is after September 25th is, I believe, a leap back to page 3, for November 2nd. Yeah. So if you can try to find page 3 of 5.
Yes.
And you see it says date November 2nd, 2025.
Yes.
So that's the next chronological date. And that was, so that would be the first new allegation that hadn't already been decided. And that would be the one I'd ask you to talk to me about now. Talk to me about what happened and why you think it placed you at risk of personal harm.
I was not there on that date. I was at work. And the respondent filed a police report. It had nothing to do with me.
Okay. So we will skip ahead then back to the final page and try to find the next chronological event to see if it had to do with you. And that would be at the top of that last page. The date is November 8th, 2025.
Yes.
Are you there? Okay.
Yes.
So talk to me about what happened on November 8th, 2025 and why it made you feel at risk of harm to yourself.
I was in my driveway and I brought a friend with me to work on my Honda because it wasn't starting and Garrett was not able to go to the property and I don't know how to work on a car, so I brought a friend with me. I was still allowed at the residence and it was about 2 or 3 in the morning and Mr. Fisher randomly drove up the driveway with his truck and his lights and he was honking. We were in the residence and we heard honking, so we walked out and I was standing behind my Honda that was parked in the driveway and we were waiting for the battery to charge, so we had it hooked up to power and Mr. Fisher kept honking and he had his brights on in his truck and he started going forward really fast and driving towards me, and I asked him what he was doing. I took my phone out to record him, and he basically, I don't know if he was intoxicated or not, but he seemed like it. He was yelling things out the window and drove towards me, and he didn't stop until my friend Jesse came out from my residence, and he saw him standing behind me, and Mr. Fisher knew that I was there alone without Garrett. And he didn't stop until he saw my friend standing there.
The last thing you said was that he knew something. How did you know he knew whatever it was you just said he knew?
He knew Garrett wasn't allowed there because there was a no contact order, so he knew I was alone.
Okay, so there was a no contact order between him and your partner?
Yeah, Garrett was banned from the property, from the criminal case.
Okay.
That has nothing to do with me.
So when you were asking him what he was doing, where was he?
In his truck, with the windows
Parked
down.
or driving?
Driving towards me. He's never been up there that late, and I don't know what he was doing up there. I assumed he was trying to intimidate me, because I've never seen him up there that late. And I wasn't doing anything wrong. I was just trying to start my car. I was working on my car.
Okay, so that means that you are worried about your safety because, fill in the blank.
Because he drove his truck towards me in a hazardous way, and he likes to use intimidation tactics while I'm there alone. I don't feel safe being there by myself when I know Mr. Fisher's on the property, and I don't know where he is. He claims he's in Texas, but I don't
Are you
believe
ever
that's true.
there by yourself anymore?
I haven't been in a couple weeks. I've been at my grandma's taking care of her.
And when you go get your property, are you going to do that by yourself?
Hopefully no. Hopefully Garrett will be with me. But I wasn't there at the other case, so I'm not sure.
Okay, let me hear about November 9th, which is the next one down.
So after that incident, I didn't want to go back to the property, so we sent one of my friends there and his wife and his 3 children, and they had permission to be there because this was still my residence. I gave them permission. I gave them a house key. They were feeding my cat and grabbing stuff for us, and Mr. Fisher, we have the police report.
But you weren't there that day.
I was not at the property.
So there was not a threat made to you, or there was nothing done to you on that day.
They were retrieving my property, and he called the cops on them saying that they were burglarizing his shop, which was not true because they had no access to the shop, and they didn't even try. So I sent an agent there on my behalf.
How is that a threat to you?
Because I didn't feel safe from the previous incident the day before. I was trying to get stuff out, and then he called the cops on them, and they were not allowed to grab my stuff for me because of what Mr. Fisher did. And
How do you know that all went down? Who
my
told you
friend
that?
called me, and then Garrett got the police report.
I'll object to hearsay, Your Honor.
Sustained and stricken. Okay, so the November 12th date, which is the next one below that, what happened that day, and why did it make you feel unsafe?
He towed my car. It's the only thing in the world that I own. He knew days previous that he saw me and Jesse on the cameras working on my car, that it wouldn't run. He also had a boat parked right next to it that was taking up half the driveway. You couldn't even drive past it, blocking his other garage, his other shop on the other side. I have pictures of that for evidence. And my car was not blocking his in or out. He moved the boat, and then...
Were you there when he called in the tow?
I was not. I was at work, and I got there afterwards, and my car was already gone, and the boat was gone. And I tried to text them and ask them where my car was, and they ignored me and just drove away. They were, like, in the shop.
How did you get to work without your car?
I was using Garrett's car because my car was not running, because the only person I had to work on it, they kept calling the cops on. So...
Okay. So that's the last one, because we had already talked about the October 1st one that was out of order below that. So to summarize, why you think he was threatening you with harm and you were at risk of harm, what would you say in summary based on those new things that happened after your last hearing?
He's continued to harass me. He towed my car when he knew that I was trying to work on it. He was preventing me from having someone come there and work on it. And I don't feel safe at all going there without Garrett or someone else. But every time we send someone else there, he causes a disruption to their lives. My friend has children, and I don't want the cops called on him. He wants me to move out, but I don't know what I'm supposed to do with a car that barely runs. The car that we have barely runs. It was totaled. It was given to us by Garrett's dad, but that car is mine, and I have never done anything to Mr. Fisher. I wasn't involved in the criminal case, and that has nothing to do with me, but he hasn't ran at Garrett. He hasn't drove his truck at Garrett. He hasn't tried to run him over. He didn't tow Garrett's car. He's doing all of this to me, and I don't know why.
Okay. Would you like to ask her questions, or would you like to direct your client?
Just a few cross questions, Your Honor.
Okay.
Thank you.
If you would get a microphone close to you, I can't hear you with that. Or just Yeah, bend it. There you go. Thank you.
Ms. Crow, just a few questions. I'll try and keep it short. You said that at 2 or 3 in the morning, Mr. Fisher showed up.
L. Crow as petitioner and Terry Fisher as respondent. This is case number 25PO11348. Time set for a trial scheduled on this Family Abuse Prevention Act restraining order. Actually, it's an Elder Abuse Prevention Act restraining order, so this is an incorrect order I just noticed. So you might want to get in touch with them downstairs about that. So first, you are Ashley Crow, correct?
Yes.
Okay, and you are here representing Mr. Fisher.
That's correct, Your Honor.
Your name and bar number, please.
Nicholas Smith, SMITH 1.
I can't hear you at all. Can you maybe move the microphone a little closer?
Nicholas Smith, SMITH 146271 on behalf of Mr. Fisher.
And Mr. Fisher, you are here remotely. I can't see you.
Yeah, I don't know how to make it turn on, but I am here.
Do you have a camera on your computer or phone?
Yes, it's a iPad.
So,
It's just
so there should be a little picture of a camera that you can click on to remove the slash mark, and that would get us your visual. It would be around the edge of your tile somewhere.
there's a microphone, and that's all I see.
Okay.
We're messing with it.
Okay. Well, it would be really helpful to get a visual. So,
Yeah, we're trying here.
Yeah, we don't normally allow remote appearances at all on Abuse Prevention Act matters. So
There it is. Is that it?
No.
It came on our side, so let me mess with it some more.
Okay. So, Ms. Crow, my understanding was that you had a request this afternoon. Is that correct?
Yes.
Okay, would you stand up and tell? Okay, we can see you now. Thank you, Mr. Fisher.
Okay. Thank you.
If you would, stand up and tell me what your request is.
I would like to ask for a continuance due to not having adequate time to prepare all my evidence. And I need the chance to get a lawyer. And I just found out that Mr. Fisher had a lawyer today by coming to the courthouse and asking. I guess they mailed out the notice today.
They filed a notice today, but there was something from Mr. Fisher a week ago that said that he planned on using Mr. Smith. That was in the file for a week.
I got it downstairs from the courtroom and the office, and
You've given me a couple of different reasons, and one of them is that you say you haven't Are you unable to stand?
No,
is one of your okay? I know you said that you had some disabilities. If you're not able to stand, then that will be accommodated. But you said at the beginning that you hadn't had time to prepare your evidence, which was a surprising component of your request since you were the one who filed and you were the one who originally was presenting information to the court to get that temporary initial order.
Yeah,
so what do you mean by you have
There's been new evidence. I just got his evidence from his lawyer today, just now, when we walked in here. And I
Okay, so the evidence that you would have to prove would simply be the things that you proved to get the temporary order. Anything new would not have been relevant to whether that order was rightly issued.
He also has not complied with the order. I have not received my car back. He illegally towed it in this order. That's why I got it in the first place, and he was supposed to give it back to me, and he hasn't.
Wait, you got a restraining order in order to get a car that he didn't give you?
He illegally towed my car from my driveway, and he was not supposed to. A judge signed the order saying it was an illegal tow and that Mr. Fisher was supposed to give me my car back. And then he...
What judge in what case?
Sorry, one second.
Okay. That wasn't in this case, was it?
It was in my original restraining order, yes.
It was this case, Your Honor.
It was?
May I assist?
Yes, please, Mr.
Yeah.
Smith. I'm trying to get into the computer as we speak.
Sure. Judge Gannett, I believe,
Gannett, yes.
signed the original ex parte request, which I believe what Ms. Crow is referencing. This is the second EDAPA that Ms. Crow has filed, the fifth if you count her co-tenant and partner.
No, that has nothing to do with this.
As far as this case, Your Honor, 25PO11348, there was an allegation in part of a petition that Ms. Fisher had unlawfully and illegally towed her car. That ex parte petition was granted by, I believe, Judge Gannett, and Mr. Fisher requested this hearing. So Mr. Fisher was not served until, I believe, like a week and a half, maybe 2 weeks ago, when he requested this hearing. I might be fuzzy on the dates when he was served, Your Honor. But the
Okay,
allegation...
I've just found there were two orders in the file, one of which is blank, but I think I've just found the one that was initialed by Roxanne Scott,
I'm sorry,
who
Your Honor.
granted that temporary order. It was not Judge Gannett.
I apologize, Your Honor.
There was another extra... There was a request for an other order of put an end to the illegal surveillance, require all security cameras installed after my tenancy be removed and not installed where my movements can be intimately tracked, my audio illegally recorded, and order no stalking of any kind, and that was denied. But I am looking to see, okay, so Section 7, money and property, said respondent is restrained from exercising control of petitioner's money or property and prohibited from transferring to anyone other than petitioner and ordered to return custody and control of the following money or property to petitioner by November 21st, 2001 Honda Accord EXV6 illegally towed. So there was an order by Judge Scott in that temporary order to return that vehicle. It looks like she's saying that has not occurred. Can you tell me, Mr. Smith, your position on that?
Yes, Your Honor. By the time that Mr. Fisher was not served with a copy of the restraining order until that time had elapsed.
So it was after November 21st that he was served?
That's correct, Your Honor. And so at that point, that would have been moot. When he was served, he immediately requested this hearing. And we can touch on...
So December 10th was when that request came in.
I have evidence that the sheriff's office tried to serve him multiple times and that he was evading
Trying
them.
is not doing. So until someone is served, an order is not effective.
That would be the respondent's position as well, Your Honor.
So you're saying that the date that we received his request for hearing, December 10th, is the date he was served because... Oh, wait,
December
sorry.
10th is what the certificate of
Proof
service...
of service, return of service. Actually, it says he was, served on December 10th at 8:57 a.m.
Correct, Your Honor.
Here
I
at the
believe Judge
courthouse.
Scott's order required him to return the vehicle. Obviously, that happened ex parte, and there was no preliminary finding that the car was actually illegally or unlawfully towed, which is what we'd like to get into today.
Well, there was a finding. It was a finding in a preliminary order, but
Correct,
there was
yeah.
a clear order that it be returned. And so in the last 3 weeks, that has not been possible.
No, Your Honor, it has not.
I have
Why is that? What's so difficult about it?
Well, Your Honor, Mr. Fisher's not in possession of the vehicle. He's not a registered owner, and so he can't demand the third-party tow truck return. Well, I mean, there's a few things happening here, Your Honor. It was the first thing that the court touched on, which is that by the time the deadline had come, Mr. Fisher still was not served. He was in Texas. He was not trying to evade service. So by the time he was served, Your Honor, that deadline had already come and gone, which I think rendered it moot. But even if he was able to comply, well, even if it wasn't moot, he's unable to comply with that order, Your Honor, because he's not in possession of the car. If he's not in possession of it, and he can't force the third-party tow truck company who has a lien on it to return it to Ms. Crow. He can't go there.
Well, if he requested that it be towed, and if a judge, i.e. Judge Roxanne Scott, ordered that it be returned because it was illegally towed, presumably he had the capacity to pay whatever needed to be paid to get it back to her, and he simply did not do so.
That's not my understanding of how tow yards work, Your Honor.
So he did not request that it be towed?
He did.
He requested it be towed, but the requester...
But once he requested it could be towed, he had no further ability to do anything about the fact that he got it towed?
That's correct, Your Honor. When you go to a third-party tow yard to retrieve a vehicle, you need to present documentation that you're the licensed or registered owner of the car. The tow yard won't release the car to third parties, even if you're the person who originally called to have the car towed.
Excuse me.
We'd like to put in evidence today, Your Honor, now that my client has an opportunity to respond to these allegations regarding...
So what is your position on her request for continuance?
We would object to that request, Your Honor. Mr. Fisher is anxious to put these matters behind him. He's retained counsel for all 4 of the prior restraining orders, which were dismissed summarily after hearing. 3 of them dismissed summarily after hearing. This petition, Your Honor...
You said there was only one with this person? You're compiling other people's restraining orders?
Yes, Ms. Crow's spouse and co-tenant has filed 3
Those are
additional.
separate orders. That have
Yeah,
nothing
we're
to
just
do
dealing with 2 people here. I'm familiar with the fact that there's a larger group that has had interactions, but we need to follow the same rules that we always do, which is to say we're not going to expand this petitioner to be other petitioners.
Well, then if we narrow it to just the petitions that Ms. Crow has filed, there has been one that went to hearing.
What was the case number on that?
Your Honor, that is 25PO.
Do you know that case number, Ms. Crow?
I don't think I have it with me for this.
08727, Your Honor. 25PO08727.
Ms. Crow, is it okay with you if I look at that file?
Yes,
Okay.
I think so.
And why don't you both go ahead and be seated while we're working out these preliminary matters? It's gone on longer than I expected. So accepting the fact that your client would like it to be over sooner than later, your client was allowed to appear remotely from another state, extraordinarily unusual in a restraining order case. How is there any prejudice to him if it is continued? He's not being terribly inconvenienced here today.
My client has a 14th Amendment due process right. Currently, he's restrained, and
Well, my point being, he's thousands of miles away in another state. So how does that restraining order impact his daily living at all if we were to continue it for another week or 2?
I also have...
Stop. Let me get his answer.
Well, Your Honor, there's obviously a financial impact to sending counsel to these hearings. I also think, Your Honor, that the motion is not timely. I mean, we're here today. Ms. Crow could have made this motion at any point in the last...
We continue restraining order trials regularly for the very reasons that she's asked, which is the other person showed up with an attorney, usually in person. So saying that it is not timely when these hearings have to happen within a very short period of time after the request is not a
right, Your Honor. The reason
not a persuasive argument. Do you have any other arguments besides
Your
it's
Honor,
not timely?
I think the legislative intent...
Maybe don't talk at the same time when I'm talking.
Sorry,
as
Your
well.
Honor.
Go ahead now.
The legislature, Your Honor, requires these hearings happen so quickly after the request for that very same 14th Amendment due process reasoning. Your Honor, Ms. Crow is currently holding possession of Mr. Fisher's residential unit. The inability to visit his property otherwise...
Is that under an agreement that was made in the eviction case?
Yes, Your Honor.
So they all agreed that the tenants, hang on just a second. I will let you talk again in a moment. I was not there that day. I had been assigned the eviction case twice before, but I was not in the country that day. So my understanding is that an agreement was reached. I don't know what the agreement was.
Point of clarification, Your Honor recused herself because Mr. Fisher's attorney was Mr. Ainsworth, who,
Oh, yes,
my
that's
understanding,
right.
has
Thank you.
represented Your Honor.
Thank you, that's correct.
That case was filed in response to Mr. Archer's taking.
What was the agreement was the question.
The agreement, Your Honor, was that there is a parallel criminal case against Mr. Archer. There's a release agreement, no contact provision. The agreement was that when the DA and Mr. Archer amended the no contact agreement that was part of Mr. Archer's criminal case from that day, the judge in that case amended the no contact to give Mr. Archer and Ms. Crow 3 weeks from the date of the amendment to retrieve all of their property and vacate the premises. That deadline, I believe, is 9 days from now, Your Honor. Mr. Fisher wants nothing to do with the respondents for the rest of his life. He's looking forward to getting back his property and putting this nightmare chapter behind him. Today is the day that he's prepared, we're here. As the court properly recounted, this is the petitioner's case that she filed more than a month ago. So the fact that she's here without counsel and unprepared, Your Honor, in my position, our position is that's completely uncompelling.
Well, you don't get to determine that.
That's
but
correct, Your Honor.
I appreciate that you disagree.
Well, I think, again, Your Honor, Mr. Fisher has a 14th Amendment due process right. Currently, he is
Everyone
restrained.
does. That is a universal right.
Right,
The
Your
question
Honor.
is whether, in order to meet that right, I am required to try this case today, and also the greater question, which was the one I pointedly asked, was what disadvantage is there to him? And I hear you saying, well, it's a disadvantage under the 14th Amendment, which is
Right, Your Honor.
confusing and
Again,
generic.
I'd like to highlight for the court again, part of my argument was that Ms. Crow is currently detaining Mr. Fisher's property.
By agreement of Mr. Fisher.
To
So again, how is
to
that?
settle the third eviction case in almost as many months.
The operative word being settled.
That's correct, Your Honor. The case was settled. He did allow, I think, 3 weeks from the day. It was 3 weeks for Mr. Archer and Ms. Crow to remove their property. So we have 8 days left. Your Honor, I'm not sure if the court's doing a balancing test here. I understand that you're not compelled or persuaded by our reasons. I'm not sure how respondent has made any argument at all how she's prejudiced, other than the fact that she hasn't gotten an attorney, for the fact that she's had 6 weeks to do so. And again, Your Honor, the reasonableness.
But your client does tend to bring in attorneys at the very last possible minute each time, so that even
Because
the
he's
court
been
doesn't know
forced
for
into
sure
court
whether
by
that's
this
going.
vexatious.
Okay, you really like to talk while I'm talking. I get that.
That's right.
Please bear with me and just let me be heard before you try to respond.
Of course, Your Honor. I promise.
Each time Mr. Fisher has come to court with an attorney, it has been at the very last minute. Today, you filed your notice of appearance today. So, yes, there is some potential that a person who always comes in with an attorney at the last minute will once again come in with an attorney at the last minute. But I'm not sure that's something that anyone relies on. Certainly the court does not until we receive a notice of appearance. So why would we expect a pro se petitioner to anticipate that without having
Your Honor,
had access to
respectfully, I don't
it?
understand why coming with an attorney, whenever he retained an attorney, I don't know why that has anything to do with this motion. I mean, again,
Because she's
whether or
saying
not-
she wants to get an attorney because your client has an attorney. That's a very common reason to request a continuance.
Well, I guess, Your Honor, it is true that last week was Christmas, and Mr. Fisher called me on Christmas Eve, and this was the soonest that I could notify the court that I would be appearing on behalf of Mr. Fisher today.
Sure. Is there a reason that every other time it's always on the last day as well?
I can't.
Is
speak
it
to
always
that.
Christmas?
I
Or?
can't speak to that, Your Honor.
Okay. Okay, so I have completed my questions at this point to Mr. Smith. I'm going back to Ms. Crow, who thank you for being patient. I know you also wanted to interrupt but held your tongue. So what more would you be doing if I were to continue this for 8 days or so? What else is there to do, and what attorney would you be getting on board for yourself?
I have to figure that out. I am currently homeless since this all started. He took the only thing that I own in the entire world.
So you're not still living at the property under the agreement?
No.
You're getting your things out of the property under the agreement?
We're supposed to be, but I have not been back. I don't feel safe going there alone. And I also have something from the sheriff's office stating that the respondent does not live at the address, and he's in an unknown location.
Well, he's in Texas.
That's just what it says on the order.
Okay. So you don't believe he's in Texas, even though that's the number we dialed today for
I have no idea.
his remote appearance?
I don't know.
Okay.
And I was not at the hearing on the 10th.
So it sounds like you have not been and do not intend to actually meet the terms of the agreement under the eviction case.
I plan on it. It's kind of hard to move everything without my second car, and I don't have the money to do that.
So once again, if I were to continue this restraining order case, what would you be doing if I were to continue it a week or so, assuming I could get a date for that? How would you be better prepared then than you are today? It sounds like you can't afford an attorney. You haven't contacted anyone. You don't have anyone who's offered to do it pro se.
I've tried.
Or offered to do it pro bono is what I meant. And it sounds like the only evidence you're claiming you don't have would be new evidence that would not be relevant anyway, because you have to only prove what happened before the day you got your temporary.
Yeah. I would get an attorney. That's what I need. I really need this to continue so I can get my car back and move my stuff out.
But you haven't reached out to any attorneys since the time you got the temporary order? And the ones you've reached out to have said that they can't represent you?
Yeah, and I was also gone for almost 2 weeks. That's why I wasn't at the hearing. I was taking care of my grandma because she had a major surgery on December 10th. And I was like 3 hours away. I'm her only caregiver. That's what most of my time has been spent on.
Hang on a minute while I look at your other file. It looks like the petition in your prior restraining order was almost the same.
He threatened to tow my car, and that's why I got it, to prevent him from towing both of our cars.
Your Honor, may I?
Not yet. Sit down. Okay, so in that case, it was Judge Van Rysselberg who granted the temporary, and there was a request for hearing. That said it's possible he would have an attorney. There was a motion to expedite without an attorney. And then the request for hearing resulted in, which was filed on September 5th, resulted in a order dismissing restraining order on September 25th by Judge Gannett. That's where the Judge Gannett name comes in. It looks like Mr. Fisher had an attorney named Aurelia Erickson at that time, and petitioner was unrepresented. So when you came in on September 25th, did you present any evidence to Judge Gannett? I need you to try to remember that. Did you give any testimony or get put under oath?
I don't think he let me.
What do you remember happening on September 25th?
I think that's the one that got dismissed. And then I asked him what happens if he tows my car. And I don't remember his response.
Is it okay with you if I listen to those proceedings in my chambers?
Yes.
Is it okay with you if I do that?
Yes, Your Honor. May I be heard?
Yes.
Before Your Honor retires to chambers to review those proceedings, I think Your Honor is touching on exactly what our preliminary motion would have been, which is that the allegations in the prior one, which did go to hearing and was decided on the facts after opportunity to be heard, I believe that the...
Okay, you're sure of that?
That's my understanding, Your Honor. I wasn't present for that.
I thought you said a few minutes ago that it was summarily dismissed, which summarily to me means without evidence.
I'm sorry, Your Honor. What I meant by that was not dismissed without evidence. It was dismissed after a hearing.
Okay.
What I mean was it was categorically dismissed without qualification.
Okay.
Dismissed, and it wasn't a difficult decision, is what I meant by summarily. That did go to hearing. So, Your Honor, the allegations are recycled in this petition as well, several of them. There's only one new substantive new allegation.
The towing?
So, Your Honor, what I wanted to do
And that is the towing?
Yes, Your Honor. So I wanted to do is streamline this and say, Your Honor, these things have already been litigated. They're subject to res judicata and issue of preclusion. I know Your Honor doesn't want to talk about Mr. Archer's three other, but those allegations were also recycled in that. In fact, they're almost verbatim, carbon copied, drafted.
Yeah,
So,
I don't think collateral estoppel applies to restraining orders. Res judicata may well apply, but I would have to find out for sure that there was a hearing.
I did do some research and I tried to find exceptions for restraining orders. I wasn't able to, Your Honor. So it's my understanding that even if there's no authority out there which conclusively allows or bars the defense of collateral estoppel, Your Honor, what I'm getting at here is that these issues have been litigated several times already after hearing between the same parties on the same side of the V. Judge Gannett heard the evidence, made a determination that all of the issues that are alleged in September, October, August, July, all of those do not rise to relief or remedy under the ADAPA statute. The only allegations that are new or novel that have not been litigated relate to this tow. We anticipate the evidence today will show that that was not an unlawful tow. It was completely legal, authorized by ORS Chapter 90, 485. Mr. Fisher made that decision after consulting with his then attorney, Harry Ainsworth, who advised him that though he had the right to immediately tow the car after looking at all the evidence, they nevertheless gave them a 72-hour courtesy notice before. Your Honor, we'll also adduce evidence this afternoon, if we get to hearing, that Ms. Crow and Mr. Archer were previously notified by Mr. Fisher's former attorney that their property constituted a obstruction to ingress and egress. Those are exhibits that have already been tendered to the court. So, Your Honor, the argument that we want to present today is that these are recycled claims. They're part of a larger strategy for Mr. Archer, and Ms. Crow to engage in a flood of expensive litigation to wear down my client. Most of these claims barely have any.
Do you know how to pull the FTR record to help me with this? Okay. Please do work on that. Go ahead, Mr. Smith.
Mr. Fisher has been hit with a flurry of motions and litigations in cases in a 5-month tenancy. He's spent thousands and thousands of dollars defending these bad faith claims, which get routinely dismissed. So, Your Honor, I apologize for interrupting you. I don't want to get off on a bad foot with the court, but my client's frustration is that he is being abused by these litigants And the notion that Ms. Crow needs an attorney today is completely undermined by all the other cases in which Mr. Archer has, and the court has commended him on his abilities to successfully master the rules of civil procedure without having gone to law school.
Right, but these folks just aren't interchangeable. And the point on collateral estoppel is that a restraining order matter involves whether someone is in danger of harm. So you can't collaterally estop one person because someone else was found not to be in danger.
And I agree, Your Honor. I mentioned these facts, and I apologize. I mentioned these facts only so that
I think I understand why you're giving me a context. Yeah. I'm also needing to keep the record clear on my thoughts.
Of course.
I'm going to take the recess to listen to that FTR. I don't know where that will lead this conversation, but I want, before I take the recess, Ms. Crow, to let you know that you may well be proceeding today to need to give me evidence. So while I'm recessing, I don't want you to waste your time. I want you to use it to try to look at the things that you would be presenting to me and get ready to make an opening statement and to give some testimony. Does that make sense?
Yes.
Okay, I'm not saying that's what's going to happen, but I would hate for you to waste the time. So you guys will not be conversing with each other during this recess. And I don't know how long it will be. You know better than I do how long that hearing was. When there's no talking on the record, that it's all recorded as we're doing right now. When there's no talking, I can fast forward, but overall, the time it takes to listen is about the same amount of time it took to do. So I'm going to go do that now, and I will return as soon as I've been able to get the facts.
Thank you, Your Honor.
Thank you.
All rise.
Mr. Garrett William Archer. This is case 25 CR 62396. Defendant is not present. I believe we have Attorney Ainsworth on the phone with us. He represents the alleged victims here. Alleged victims are requesting modification of a no contact order. The state does not object to this request.
You're going to have to repeat.
Good afternoon.
You have to repeat yourself because the door was open and people were talking. What's the last thing you said?
Yes, Attorney Ainsworth is here to represent the alleged victims. They are requesting modification of the no contact order to allow very specific communication between 9 a.m. and 6 p.m. 7 days a week for the next 3 weeks so that the defendant can grab property and move out of an apartment. Judge, the state has no objection to this request.
Okay, Counsel Ainsworth, the DA has no objection to that. Is there anything else you wanted to say?
So we would be, if somehow it can be mentioned that there be no further damage to the premises, we intend to have the visit supervised, and it would be nice if Mr. Archer would give us advanced notice on the days when he's supposed to be there. My client will be out of town, so there won't be any direct contact between the alleged victim and the defendant.
Right.
And that 3-week period starts if the court decides to make this modification. The 3-week period starts when the modification is made.
So you want Mr. Archer to contact you regarding setting a date?
Yes, that would be fine.
Okay. Are you going to be present, or did you have another supervisor in mind?
There will be somebody else other than me. My client will hire someone, I believe. There's a lot of stuff that needs to be removed.
Okay. So is it Terry Fisher that would select the supervisor?
Yes.
What's your first name, Mr. Ainsworth?
Oh, I'm Harry. Harry.
Could you say that again?
Harry.
Oh, all right. Thank you.
You're welcome. So my daughters say because I have an East Coast accent, it's difficult for Oregonians to hear my name, to understand it.
I don't think it's the accent. I think it's the remote appearance.
Okay.
Okay, so the order reads, shall only be allowed to have contact with the victim with the following restrictions. Access to the property to remove personal possessions limited to 9 a.m. to 6 p.m., 7 days a week for 3 weeks starting today, which is December 18th. After 3 weeks, full NCO, meaning no contact order. Supervised, I'm going to write down access supervised by person selected by Terry Fisher and defendant to contact Harry Ainsworth, the attorney for Terry Fisher, regarding time to access property. Does that sound acceptable with you, Mr. Ainsworth?
That's fine, Judge. Thank you.
Any problem with that?
No
DA?
objection.
Okay, it's signed, and I think I'll cover everything. Thank you.
Judge, that should be
Thank you very much.
on the 1:30 calendar.
All right, thanks.
Thank you.